This is Chapter 1, Learning Objective 2, in which we're going to examine the record-keeping requirements of some of the employment laws. The Title 7 of the Civil Rights Act of 1964, primary thing is the equal employment opportunity, which basically says everybody gets an opportunity at employment and you can't discriminate. And then the Civil Rights Act specifically prohibits discrimination in hiring, firing, promoting, or compensating based on color, race, religion, national origin, or gender. And this applies to all employers who have 15 or more workers. The Civil Rights Act of 1991 made it possible for people that had experienced discrimination intentionally to not only get back compensation, but also punitive damages, which basically means, it's a punishment for the suffering that they had to experience. The Age Discrimination in Employment Act basically says you can't use age to discriminate in hiring, firing, or promoting. So like on job applications, you can't ask people when they were born or how old they are. And it basically is to protect workers that are over 40 years old, because otherwise, it's very tough if you get laid off to get a job. There just sometimes is a natural intent or a tendency to discriminate. You would rather have younger hires. And it also places the responsibility, onus means responsibility, on the employer to keep accurate personnel and payroll records. And again, this is job security for those of us that work in the area of payroll accounting. The Americans with Disabilities Act, the ADA, prevents employers that have more than 15 or more employees from discriminating against qualified persons based on disability, which basically says if they can do it, the job, then you have to hire them. And the kind of the tricky thing in this is you have to provide reasonable accommodation to enable them to do it. So reasonable is very vague. It means you don't have to turn everything upside down in your office, totally remodel so that maybe somebody can come in a wheelchair, but there has to be reasonable accommodation. A qualified person is somebody that could perform the essential functions of the job with or without reasonable accommodation. So if you hire them, then you have to provide reasonable accommodation. The Federal Personal Responsibility and Work Opportunity Reconciliation Act. By the way, side note, you don't have to memorize all this stuff. That's why all the tests and things are given online, so that you can refer back to this. But it's good for you to have a basic familiarity with this. I just don't want you to get overwhelmed with all this. This requires employers to report information on new hires within 20 days to the state agency. So when I start up a new company, and I do accounting for a lot of small companies, when they hire somebody new, we have to tell the state of Utah that we've hired a new person, and you can now do this online, so it makes it easier. And you have to give them all the information about your employees. And a lot of times you just have to submit a copy of the W-4, which we'll talk about later what that form is. But probably you've all filled out a W-4 for your employer. It's where you tell them how much withholding tax to take out. And the records are coordinated through the Federal Office of Child Support. And a lot of the reasons that the states want to find out if you've had any new hires is because there are people that owe child support and they're not paying it, And so if the state finds out that they have a job and that they're not paying it, then they will automatically withhold it and forward it to the person that, the spouse that's not getting the money. And there's fines associated with not reporting your new hires, up to $25. There's a few states that now require the same from independent contractors, meaning you have to report if you're having an independent contractor do work for you. So that's quite a bit more responsibility. I don't think the state of Utah's got that requirement in place at this point. And as I had mentioned, this whole idea of reporting new hires is used to help enforce child support obligations. There's also the Immigration Reform and Control Act. There's a law that bars hiring and retaining aliens unauthorized to work. So a lot of times the state or federal agencies will go into companies, and especially those that hire a lot of illegal immigrants, and demand documentation for their workers, and they have to let go of all the workers that are not legal, and there's often penalties for the companies that are hiring them. One of the key things is employees have to complete an I-9, and if you've had a job yourself, you filled out one of these forms. And it has to be done within 3 business days of the employment. We'll talk more about this in a later chapter. And if you don't have your employees fill out an I-9 and you're hiring illegal employees, there could be penalties to $110 to $1,100. And criminal penalties can also apply if they can see that you've discriminated, like maybe you've hired illegal immigrants and not legal immigrants. There's a system out called the E-Verify, which allows the employers to check the employment eligibility by cross-matching the I-9 information with the Social Security Administration. And this helps because the I-9 is a form, and it requires identification that the employees submit, like a passport or a birth certificate, but a lot of that stuff can be forged. This matches, and it basically is a much more secure way to determine if you really are hiring legal immigrants. There's also the Family Medical Leave Act, known as the FMLA. This covers employees or companies with 50 or more employees within a 75-mile radius of the headquarters, and the employee is guaranteed 12 weeks of unpaid leave. If this was overseas, some of the European countries, they get 12 weeks or somewhere around there of paid leave. But this says you can have 12 weeks of unpaid leave for a birth, an adoption, caring for a child, spouse, or parent. You can use it all at once or at separate times, but it has to be within 12 months of whatever event occurred that's causing you to take leave. And during this 12 weeks, the employer has to continue health care coverage. They can't cut you off. And you have the right to return to the same job or a comparable position. So a lot of times employers will have to just hire a temporary person to cover your position while you're gone. This has been expanded to include up to 12 weeks if a family member is on active duty, or it's up to 26 weeks if you have an injury or illness that came about because you were acting in the line of duty. So this is basically for the military personnel. Some states have paid family leave plans. I don't think Utah is one of them. There's the Uniformed Services Employment and Reemployment Rights Act. Military personnel is given the right to take leaves of absence from civilian jobs. Like they might be in the National Guard and they get called up and they have to serve. And what that gives them is the right to return to their prior job, and they don't lose their seniority. And basically they have to be allowed to come back within 2 weeks of their request. So somebody gets deployed overseas, they come back. If they want to come back to their job, once they request it, they have to be able to come back within 2 weeks. And health benefits have to be started right away without a waiting period. Now, this doesn't apply if they're dishonorably discharged. The Employee Retirement Income Security Act, known as ERISA. This all has to do with retirement. And we'll talk more about all of this in later chapters, but just to kind of give you an overview, there are trustees that have to monitor pension plans that are set up for employees. And the employees have to be able to be vested 100% in 3 or for sure by 6 years. So if you're going to do it graduated, like 20% a year, they have to be, or 15% a year, whatever, they have to be fully vested in 6 years. So what this means is, when we say vested, it just means that you get your retirement benefits even if you leave. So for example, if you had worked for someone for 2 years, you could be 20% vested, which means if you leave after 2 years, you get 20% of what was in the plan for you. If you stay for 3 years, then you'll get 40% of what was in the plan for you. If you leave after 4 years, you get 60%, on up to, 100% after 6 years. It also provides for this organization, the Pension Benefit Guarantee Corporation, which is a federal agency that guarantees benefits to employees, and they basically help oversee a lot of the pension plans. ERISA requires that you keep really strict records, and an employee is eligible for a pension plan, to be a part of a pension plan, if they've reached age 21, or if they've received 1 year of service, or have completed 1 year of service. And employers have to file a Form 5500 annually, which basically is a tax return for the pension plan. There's some current legislation going on. The big one is really in the news a lot. It's the Health Care and Education Reconciliation Act, better known as Obamacare. It was signed into law March 30th, 2010. Most of the provisions are effective 2014, though some have been extended a little bit. Beginning in 2013, single filers with wages over $200,000 and joint filers, meaning a spouse and two spouses filed together, if you add their wages together and they add up to $250,000, then they're going to have to pay additional Medicare taxes. Also, the Patient Protection and Affordable Care Act, that was also part of the Obamacare. It was signed into law 3/23/10. It offers a tax credit to small employers who are offering health insurance to employees to help subsidize, because the small employers take a big hit on this insurance, health insurance. It's going to cost them some money. If the employer pays at least half or more of the cost of the premium, then the credit is 35%, or 25% if it's a tax-exempt organization, like a nonprofit. Then you have some state laws, workers' compensation. Most states require employers to pay employees' premiums, and you don't have to do this if you are self-insured, meaning if you're big enough, then if your workers get hurt on the job, you can pay them yourself instead of having insurance to do that. And there's different premiums based upon the job class. If you, in the construction industry, the workers' comp tax is a lot more than if you're in the accounting industry, because you're going to have a lot more construction workers that get hurt on the job and have to be covered by workman's comp, meaning they get payments for their medical gets paid. as opposed to accountants getting hurt on the job. I don't know, maybe accountants could, staple their hand to something, but it's not a high-risk industry. There are also state disability benefit laws. 5 states plus Puerto Rico have established laws requiring employers to provide disability benefits. They have to, which is interesting because these apply even if the disability didn't arise due to employment. You might be skateboarding and get disabled, and the employer has to provide disability benefits.